But here I've got United States v. Charez by the Second Circuit, which is really just going off U.S. United States v. Minter. Um, and it's about New York cocaine. I think I came on your show and talked about Minter a month or two ago. But in Minter, the Second Circuit said that New York's definition of cocaine is overbroad, such that it can't be a controlled substance offense for sentence enhancement purposes, which I see no reason why that doesn't directly then apply to immigration. It would seem that a New York cocaine conviction, be it trafficking or possession,
Damn.
is nothing for
Yeah.
immigration purposes, and that's huge. But this case, Charas, first of all, is just explaining how big of a deal US v. Minter was. It seems like the Charas court didn't like it, and that the Charas court might have wanted to get to the issue first, but once Minter was issued, this other panel is so bound, and that's just appellate procedure, which is wild if you're a appellate judge,
Yeah.
who I don't think come on your podcast or mine. But maybe we can ask him if they do
Yeah.
one day. But Charas, when I was reading Charas, it showed me it was even broader than I thought, because the New York penal law that's at issue, it's New York Penal Law Section 220.391. It doesn't actually reference cocaine. Yes, this is all about cocaine, but cocaine is coming in under the statutory term of narcotic drug. So really, the holding of Minter and Charas is that New York's definition of a narcotic drug is overbroad because it indivisibly includes cocaine, which is overbroad. That's even bigger. It would then seem that every New York law that references narcotic is not a controlled substance offense, because again, narcotic means cocaine and other things, but cocaine is overbroad. So huge deal in New
Yeah.
York. Um,
If that happens in Florida, then that's gonna be a big deal.
why? Because there's a lot of cocaine. I the argument was made in Florida in Shamu. I think it was cocaine. If not, it was meth or something like that. The isomer argument, and in Shamu, I just think that the chief judge just he just couldn't go that far.
Yeah.
Judge Pryor, but he didn't. As I read Shamu, he didn't preclude the argument. He just said, I don't believe that this isomer of cocaine that you're saying makes it overbroad. I don't believe it exists, even
Mhm.
though they had a great expert and all this stuff. But whatever, to me, Judge Pryor outlined what they need to show next time to prove that the drug exists. So, like, I don't know, get another expert prove. Shamu to me doesn't mean anything. It just means that you have to prove to the 11th that exists. But the intellectual framework that is that a drug can be internally overbroad. The 11th has already accepted that argument in the Syed decision. They said that Florida marijuana is broader than the federal definition of marijuana because they know what seeds and stems are,
Yeah.
and Florida criminalizes seeds and stems and the feds don't. So just prove to the 11th that this overbroad cocaine isomer exists, and you got your same argument. So the fact that the 11th has already accepted the logic, as had this the 7th, the 8th, maybe probably, I mean, certainly the second, that's at least three. And if you include the 11th, the four have accepted the logic, probably more too. And you've got a heck of a situation. The Ninth Circuit actually adopted this logic many years ago, but then immediately went back and vacated the decision before I was practicing. But like, I think it's only a matter of time before the Ninth comes back and
Yeah.
analyzes this, and now it has multiple circuits to say, look, we're not an outlier here. This is happening. So immigration is the great frontier, and so much of it is actually happening not in immigration, but in the sentence enhancement context, with very smart federal public defenders making the argument, but we benefit from it just as much in the